Hello friends, welcome to our channel Khatri Steno. Subscribe our channel for more dictations on daily basis. Get ready for the dictation. Article 356 accounts for a situation where there is a breakdown, a failure, as the article states, of the constitutional machinery in the state, though this phrase is found in the marginal note of the provision and not its text. Judgments of constitution benches of this court have held that Article 356 must be interpreted with reference to the marginal note. For the President to issue a proclamation under Article 356, two preconditions have to be fulfilled, which are the satisfaction of the President that a situation has arisen in which the government of a state cannot be carried on in accordance with the provisions of the Constitution, and the satisfaction that such a situation has arisen must be formed either on the basis of a report sent by the governor of the state or otherwise. If these two conditions have been fulfilled, the President by a proclamation may assume to himself all or any functions of the government of the state, and in all or any powers vested in or exercisable by the governor or any other authority in the state, declare that the powers of the legislature of the state shall be exercisable by or under the authority of parliament, and make incidental and consequential provisions which are necessary or desirable for giving effect to the object of the proclamation. This would also include the power to suspend in whole or in part a provision of the Constitution relating to any body or authority in the state. However, the President is barred from exercising the powers of high courts or suspending any provision of the Constitution related to high courts. The subsequent clauses of Article 356 prescribe conditions relating to the tenure of the proclamation. Every proclamation must be laid before Houses of Parliament, and unless approved by a resolution by both the Houses shall cease to operate within 2 months. However, where the Council of States approves the resolution in 2 months but the House of People is dissolved, the proclamation ceases to operate on the expiry of 30 days from the date on which the House of People first sits after reconstitution, unless a resolution approving the proclamation is passed by the House of People before that. Article 356 within bracket 4 states that an approved proclamation has a life of 6 months from the date of the issuance of the proclamation, not the date of approval, unless another proclamation approving the continuance of the proclamation is passed. This proclamation also has a life of 6 months. Thus, Parliament may approve the proclamation in the first instance, which then has a life of 6 months, and thereafter also approve its continuance, which shall extend the life of the proclamation by another 6 months. However, Parliament shall not pass a resolution approving a proclamation for a period beyond 1 year since the date of issuance of the proclamation, unless a national emergency under Article 352 in operation in the whole of India or whole or any part of the state, and the Election Commission of India certifies that it is necessary that the proclamation continues to be in force because of the difficulties in holding general elections.